A new filing just filed in the Kelsey Fitzsimmons case. So here we are to break down and explain this filing to you. Now, just briefly to catch you up onto what's been going on with Kelsey Fitzsimmons up until this filing. Kelsey Fitzsimmons is a North Andover police officer who was shot. She was shot in the chest, taken to the hospital, treated for 53 days, and miraculously made a recovery. Now, she's still injured, very injured, in fact. She has broken ribs and some other internal organs that she actually still needs surgery on. But that didn't stop the judge from imposing some restrictions on her bond. She eventually did get bond, and one of the restrictions were that she has to blow into a scram device. Now, to blow into a scram device is not so simple when you have just been shot, because you have broken ribs and some other internal organs that make it very difficult to breathe in the first place, let alone breathe hard and deep into the scram device to test you for alcohol. Well, you may be asking, well, why is this testing for alcohol necessary for her bond restrictions? And the very obvious answer is that obviously alcohol had a lot to do with the crime that she's being charged with. Well, actually, no. Alcohol has nothing to do with the crime that she's being charged with, but nevertheless, the judge still imposed that restriction on her. Well, her attorney very dutifully filed a motion to have her bond modified, to have some sort of alternative way that she can test for alcohol. And the judge got so upset at the hearing that she just stormed off the bench and said, sorry, we're revoking your bond, sua sponte, without any notice, without a hearing. Your bond is revoked. Have a nice day in jail. And she's been sitting in jail since then. So her attorney filed a motion for reconsideration. He filed an appeal to a single justice, and now they filed an appeal to the full panel of the SJC. So this is the last filing. This is the reply to the Commonwealth's response to their initial appeal. So there's an initial appeal filed by Kelsey Fitzsimmons' attorneys. Then there was a response by the Commonwealth, and now this is the reply. This is the last filing, and now we just have to wait to see whether there's actually going to be oral argument on this issue, or they're just going to rule from the bench. So that we have still yet to see, but this reply just came in, and it's a doozy. It's a really good one. So let's pull it up, and we'll go through it. You know, I don't usually like to read everything, but this is it's a pretty short, and they bring up a lot of good points, so we might have to get through a lot of it. All right, so as you can see here, reply brief for appellant Kelsey Fitzsimmons dated December 3rd, 2025, which, if you notice, if you're watching this video today, actually, this is December 3rd, 2025. So this is hot off the presses. So table of contents, we don't have to go through that. Come on, that's too boring. But let's get into the introduction. So here we go. Now comes appellant Kelsey Fitzsimmons and respectfully submits her reply brief in the instant manner. The Commonwealth submission to the full bench dramatically expands its position far beyond the limited scope asserted in the trial court hearing under appeal and raises new issues that were neither presented nor litigated by them below. So you can't just change your position whenever you feel like it. You take a certain position, that's the position that you got to stick with. But they tried to change their position. And we're talking about the Commonwealth here. Appellant addresses those new contentions herein in the context of the appeal, whether the Superior Court's revocation of release issued sua sponte without notice, very important word there, without notice, without proper findings, and without adherence to that statute, constituted an error of law warranting relief under SJC Rule 221. A number of different arguments that they go through, but they're all pretty brief, and they all really they lay it out very nicely here. So here we go. The first issue is that the Commonwealth's brief improperly expands the scope of the appeal. Before the Superior Court in the hearing at issue here, the Commonwealth stated only one simple request: to maintain alcohol monitoring. That was the request. Now, appellant held under the court's order, agreed in principle, but by different means, and the parties were not in opposition on this issue at the hearing. Remember, at the hearing itself, everybody agreed that we can modify her bond. There's no issue here. The probation officer was not opposed to that. And of course, she was not in violation of any restriction because she did eventually actually blow through that scram device despite the excruciating pain that it caused her. So everybody kind of was in agreement at the lower court level. So they all agreed that, okay, you can have the alcohol testing if you want, but let's just do an alternative way of testing. The probation department likewise agreed there was no violation. Despite this narrow framing, the Commonwealth now submits a 41-page brief. And we went through that brief, by the way, addressing everything under the sun, disputed facts, praising and defending the Superior Court's actions, and presenting a narrative far beyond the scope of the question that was before the single justice. This expansion is inconsistent with the procedural posture of the appeal vis-a-vis the Commonwealth and obscures the core issue. There's only one issue here: the lawfulness of the Superior Court's sua sponte revocation of bail. That's it. That's the entire issue. You don't have to litigate the entire case right now. The Commonwealth relies on allegations the grand jury did not credit. The Commonwealth's principal factual argument relies on the assertion that appellant pointed a loaded firearm at a colleague, pulled the trigger, and attempted to fire again. And that's what they laid out in the response. That's what the Commonwealth laid out in the response to the appeal. These allegations were presented to the grand jury. If credited, they would have supported the requested charge of armed assault with intent to murder. They tried to get her on an armed assault with intent to murder. Now, if she pulled the trigger once, that means that she intended murder. But the grand jury did not indict her on that. So that has nothing to do with this appeal, nothing to do with the case. The grand jury rejected that theory and returned only one account of assault with a dangerous weapon, an entry-level superior court offense. The notion that appellant intended to murder a colleague cannot be treated as a credible allegation where the grand jury declined to indict on that basis. You shouldn't be talking about that as though it's a fact in the case or even a disputed fact in the case because the grand jury disregarded that. So you can't say, well, the grand jury got it wrong, and it's too late. We're dealing with this case as though the facts are that she did not pull the trigger. Yet the Commonwealth's brief repeatedly presents these rejected allegations as though they are findings of guilt or fact. Dangerousness determination must be tethered to reliable evidence, not accusations that failed at the grand jury stage. You can't use that fact that you're trying to pretend that happened here, that she pulled the trigger, and say, well, you see how dangerous she is. Because the grand jury ignored that fact. They rejected that fact. So if they rejected it, you can't bring it up as though it's a fact in this case, or even a disputed fact in this case. Continuing. The Commonwealth lacks standing to defend the Superior Court's sua sponte revocation. This is always a great argument to make, that you don't even have standing to be here. You can't even file your opposition to our appeal because you don't have standing to do so. Because the Commonwealth neither requested revocation nor argued for detention in the hearing at issue. Remember, at that hearing, the Commonwealth didn't say we need to revoke her bail. The Commonwealth's position was not that she needs to be detained. The Commonwealth took no position. They were very supportive of Kelsey Fitzsimmons. So you can't now at this level say, well, we get to argue the other case the other way now. It does not have standing to defend the Superior Court's sua sponte decision. The Commonwealth's stated position below was limited to seeking alcohol monitoring. Monitoring appellant agreed to, although only under the umbrella of the trial court's disputed release framework, provided it could be administered in a manner compatible with her documented injuries. So again, the Commonwealth's position was just that she needs alcohol monitoring, right? For whatever reason. Okay, we agreed with that, even though it doesn't really make a lot of sense in this case, but we agreed with it. We just said, let's do it a different way. So we're in agreement. The only question is, how are we going to test? So you can't now take a different position. The Superior Court nevertheless revoked bail without a motion from the Commonwealth, without notice to appellant, very important word there, without notice to appellant, and without findings under 58A and 58B. An argument not raised below is waived under Massachusetts Rule of Criminal Procedure 30C2. Thus, a party cannot defend on appeal a ruling it did not pursue below. Right? If you don't preserve an issue, then you have waived it. So this was not brought up. If you did not bring it up at the lower court level, everybody knows this. If you don't make an objection, a timely objection, you don't make a record, then you've waived that issue for appeal. So the Commonwealth cannot take a position now that they didn't raise at a lower level court. So you don't even have standing to argue against this appeal. That's number one. Moving on. The Commonwealth's assertion of the trial readiness lacks support in the record. The Commonwealth asserts that it will be prepared for trial in January, a backdoor way of saying that wrongful incarceration of appellant won't be that bad. Meaning, we're going to try this case in January anyway. Let's just keep her locked up for a couple more weeks. What's a couple more weeks in jail anyway? Right? That's the suggestion there. Well, no, that's not how this works, number one. And number two, we're going to see why that also fails. But at the time its brief was filed, it had not furnished automatic discovery, had not identified the firearm allegedly used, and had not provided materials necessary for independent expert review. So if you're not complying with your discovery obligations, well, then we're not going to have this trial in January because you're not giving us any information, and we need to have a defense. You have a constitutional right for a defense. And therefore, you have to turn over as a Commonwealth certain discovery, and if you didn't, well, then we're not going to have this trial in January. So number one, as if it makes a difference whether she has to spend an extra day in jail. Yeah, every single day, every single hour that someone's in jail unconstitutionally is not okay. So yeah, we're going to have the trial in January anyway. We're going to have the trial in January. Who cares? We're going to have the trial tomorrow. Still, she should be let out. This is the United States of America, after all. Assertions of trial readiness are not relevant to the question at hand, and in any event, are not supported by the current state of the record. Okay, so you're not ready for trial. Even if you would argue that you're ready for trial, and therefore, what's another couple days in jail? You're not ready for trial. Continuing, appellant's physical injuries were serious serious, documented, and directly related to her inability to perform scram testing. The Counsel states that appellant offered no medical evidence demonstrating her physical condition. This is incorrect. The severity of appellant's injuries, a punctured lung, fractured ribs, and other gunshot-related trauma was obvious, that's number one, documented, and reflected in official reports. Probation staff witnessed her difficulty performing scram breath testing due to her injuries. Nonetheless, the Superior Court failed to consider the impact of these injuries on appellant's ability to comply with the condition imposed. Don't forget that letter that they attached from the trauma surgeon. So that definitely was submitted. The issue before the court until the trial court's surprise scram ruling was her mental state and lack of dangerousness as supported by two esteemed mental health clinicians, not her physical disability. Remember, that first issue was, is she dangerous? Does she have a mental health condition? And the mental health clinicians, two esteemed mental health clinicians, both said that she is not dangerous. She is not dangerous, and she's not dangerous to herself or to other people. The Superior Court did not address the two expert opinions from Dr. Nisevich of Massachusetts General Hospital and Dr. Zeisel, concluding that appellant did not present a danger to herself or others. Contrary to the Commonwealth's statements, appellant proposed a reasonable alternative to scram testing. The Commonwealth asserts that appellant presented no alternative to scram breath testing, which is just amazing that you can even argue that. The record directly contradicts this claim. If you just listen to the hearing, it doesn't take that hard. You just listen to the hearing. We all heard it. Appellant proposed urine testing through a probation-approved vendor. An alternative assistant chief probation officer, January, identified as feasible. The Commonwealth's repeated statements that no alternatives were offered is inaccurate. And then see all the citations to the record where Bradel did suggest urine testing. Continuing, the procedural complexity below resulted from the court's unexpected concerns. The Commonwealth characterizes appellant's litigation posture as piecemeal. Right? Remember, that was one of the arguments. Oh, they're piecemeal litigation. Here, repeated filings were necessary to address matters unexpectedly raised by the trial court's positions that alcohol testing was indicated, urine testing was unknown to it, and the claim that what proof did it have that appellant's rib injury made it difficult to breathe deeply. Appellant's filings addressed issues as the court raised them, not by choice, but by necessity. Remember, they kept saying, oh, this piecemeal litigation. Like, how are we supposed to know that you're going to make such asinine rulings all the time? You know, we're assuming you're going to actually follow the law and follow the Constitution. But when you don't, then yeah, we have to keep filing stuff to remind you that there's a Constitution and that we live in America. So, yeah, you know, it's not called piecemeal. Moving on. The revocation cannot be upheld under either 58A4 or 58B. The Superior Court's revocation of release did not comply with either statutory scheme. If treated under 58B, as what this really was a 58B. That's really what it was. It was a revocation of bond. That's really what it was. Now, if you treat it under 58B, you have a serious, serious problem if you're the judge in this case, because you completely ignored the statute. Revocation under 58B requires notice, a hearing, and that's always a very important part, because notice and hearing is a constitutional right. It's called due process, which we believe here in America. Findings of willful violation or new dangerousness. So if you want to have a 58B finding, well, then there has to be a violation. So aside the fact that there's no notice or hearing and there's a violation right off the bat of a due process violation, but there's also the fact that there was no violation here. So 58B is out, right? None of these occurred. Okay, well, now they're going to try to argue, as we've seen up until now, that the argument here is, no, this was not a revocation. This wasn't a 58B revocation, even though it sounds like one. But it's actually a 58A4, which is that the judge is allowed on her own to revisit rulings that she made, right? So here's the problem. If treated as reconsideration under 58A4, due process was still required. Right? This is the strongest argument. There was no due process here. The appellee stated that the decision was not a revocation, but rather reconsideration. So they're labeling that as 58A4. So that the reason why they're doing that, the reason why the judge did that, is because she realized under 58B she's stuck. I mean, it's clear as day that she made her error there. So they tried to tie it into 58A4, which is just the judge is allowed to reconsider her rulings at any point. Regardless of label, 58A4 requires notice and an opportunity to be heard before modifying a release order. Appellant received neither. And that is true. There was no notice here no opportunity to be heard, that Kelsey Fitzsimmons' bail may be revoked. Remember, the notice and opportunity to be heard has to be on the specific issue of taking away someone's liberty. It can't be that you have notice of something else, and then while at that same hearing, we can do whatever we want. That's not how due process works. You have to have notice of what the judge may do to you at that point. And therefore, you have to have opportunity to be heard and argue for that revocation, for your liberty being stripped from you. That's what you need. And that clearly was not done here. There was none of that available here for Kelsey Fitzsimmons. Appellant's liberty may not be revoked under a statute that does not permit revocation based on the facts at hand, particularly without observing the procedural safeguards required by due process. Footnote 8 and footnote 9 of the Commonwealth's brief contain significant misstatements. Footnote 8 presents a characterization inconsistent with the record and unsupported by any judicial findings. Footnote 9 misstates the role of the full bench under SJC Rule 221, suggesting that the full court is limited to reviewing the single justice determination. In fact, where the single justice makes an error of law, the full bench performs de novo review and resolves the underlying bail question to prevent further unnecessary delay and remand to a lower court judge who would have already made an adverse and then reversed ruling consistent with Stack versus Boyle. So no, this is a de novo review, and you're not going to get the benefit of just a review of an abuse of discretion by the single justice. That's not going to happen. The trial courts and the Commonwealth's discussion of mental health history omits the uncontroverted expert opinions. The Commonwealth references appellant's mental health background without acknowledging the two expert evaluations, concluding that appellant was not a danger. Why do we keep ignoring that fact? That two mental health experts said that she is not a danger to herself or to anybody else. These opinions are unchallenged in the record and must be considered in any dangerousness analysis. Alcohol use played no role in the underlying incident. The allegations concerning alcohol derive from an affidavit submitted in a separate context by an individual with motives unrelated to this criminal matter. Remember that affidavit that we talked about in the Commonwealth's response? That affidavit who was filled out by Justin, right? I mean, if you had to trust anybody, let's just trust in Justin. Just trust the affidavit. That was the Commonwealth, basically, that was their position. Well, there's this affidavit. An affidavit filed by Justin who's in this custody battle with his old fiance, ex-fiance, and they have a child. So now let's just assume that everything that he says is just true. No police reports or charges are extant from this alleged behavior at a bachelorette party in Maine. Right? So it's an affidavit saying, yeah, she got a little drunk, too drunk at the party, and she acted aggressive. So therefore, we should just trust Justin 100%. Because why not? We should just, in Justin, we trust. No witness has been cross-examined or questioned under oath as to any of this alleged behavior. There is no rational basis to credit this piece of paper filed to gain advantage in a custodial family court matter. In contrast, law enforcement officers present on the day of the incident did not report that alcohol was a factor in any way whatsoever and found a normal mother happily at home with her 4-month-old baby, which they were trying to take away. The trial court's revocation cannot be justified based on untested allegations unrelated to the incident, particularly in the shadow of the mountain of evidence to the contrary. So because she was at a bachelorette party, and because she got drunk at the bachelorette party, and because her fiance, who hates her now and wants to take away her child, said that she was uncontrollably drunk and aggressive, well, then that means that we have to impose alcohol restrictions for something that happened a few days later. I mean, if you can follow that logic, then you can be a judge in this case. All right, let's continue. The Commonwealth did not address the ADA arguments in his brief before the single justice and therefore waived it. Appellant argued before the single justice that scram breath testing was medically impossible due to her injury and that the Americans with Disabilities Act required a reasonable accommodation. The Commonwealth did not respond to this argument, and its first discussion of the ADA appears in the appellee's full bench brief and was ignored by the Commonwealth in the single justice session. So again, if you ignore something at the lower court levels, you cannot bring it up again at a higher court level. Under Rule 16A9A, arguments raised for the first time on full bench review need not be considered. So this is another problem that the Commonwealth has here, that they ignore the ADA argument. If they ignored it at the single justice level, well, then guess what? You cannot bring it up at the full bench level. So that is the reply, a great reply, a strong reply, screaming due process. That is the argument that's going to win this case. And that is why Kelsey Fitzsimmons should, quite frankly, be out of jail as soon as possible. Then go ahead, litigate the case on the merits. Okay, I'm not saying that she's innocent. I have no idea whether she's innocent. I mean, I think there's some questions about what exactly happened there and how the Commonwealth's going to have a trouble proving their case beyond a reasonable doubt. But, We don't know all the evidence. Maybe there's more evidence, but let's just play by the rules until we get there. So Kelsey Fitzsimmons belongs out of jail. She belongs at home, and she shouldn't have to do alcohol testing in the first place. So hopefully, I have confidence. I have a lot of confidence that the full panel of the SJC is going to get this right, and Kelsey will be out hopefully soon in time for the holidays. All right, well, that's going to be it for today. That is the update on Kelsey Fitzsimmons. If you haven't yet, please subscribe. Please like. It really helps out the channel. And of course, if you haven't yet, there's a very special organization that I am going to be playing an ice hockey tournament to benefit. It's a charity. It's called RCCS. They help out families that are stricken with cancer, which those type of families, those people need as much support as they can get. This is an organization that steps in, takes them by the hand, provides the support that they need. And this is what I'm going to be playing hockey to benefit for. So if you can, any amount is appreciated. Don't send me a super chat. Don't send me anything else. Just hit that link in the description. And if you can, donate whatever you can. That would be very much appreciated. It'll go to a very, very special cause. All right, that's going to be it for today. We will see you next time.